afternoon. This is Tim Bilecki with the Military Law News Network. I'm here with Michael Waddington. Today what I want to discuss is the concept of the SVC, the Special Victim Counsel, which is unique to Air Force sexual assault prosecutions, and in particular how they are affecting trials and how they're affecting perhaps even the outcomes of the case. There's been a pretty big case that just came out or is just going up before the appellate courts on this very issue. So I'm going to turn it over to you, Mike, to kind of explain what an SVC is, what you're seeing out there, and how this new case might be affecting the outcome of some trials.
Okay, really what an SVC is basically another term for the victim's lawyer. You know, in a court-martial you have the prosecutors. Now there's usually at least 2 prosecutors in every sex assault case. You have the chief of military justice, they're also involved in the prosecution. You have the SJ, who's part of the prosecution team. He or she's their supervisor. So you have all these lawyers that represent the government trying to win the case. Well, the Air Force, over the past couple of years, had gotten complaints from some of these alleged victims saying that it's not fair, the defense is asking me really hard questions, the prosecutor didn't do a good enough job, whatever. And so the Air Force says, hey, let's add another layer of lawyers to a court-martial if it involves sex assault. Now, and what they did is they created a program called the SVC, Special Victim Counsel Program, where now the victim gets her own attorney who acts independently of the prosecution and the defense, and now they're interjected into the court-martial, meaning that they can come in there and speak on certain matters. They can argue and advocate for victims' rights during the process, and really what the main thing that they get involved in is what's called MRE, Military Rule of Evidence 412. That is what we call the rape shield statute. Now I'm going to go to you, Tim, to explain what Rule 412 is and why Rule 412 is a key battleground in a court-martial.
Well, Mike, without going into too much legal detail on MRE 412, but again, as you said, it's a rape shield. It's the Military Rule of Evidence of Rape Shield. What it is designed to do is keep out past the sexuality of an alleged victim, her past sexual encounters. It was essentially designed so defense lawyers can't come in and say, well, she's a slut, she's a whore, she had it coming. And there's good reason for that. But what's happened now is it's been rewritten so many times and it's so strict that defense attorneys can't bring out exculpatory evidence which could be out there. And let me give you a really easy example. If there was an alleged victim who had a boyfriend and she was having sex with her boyfriend and she had an ongoing relationship with her boyfriend but was met cheating on him with the accused, your client, and their boyfriend found out, then she alleged rape. Well, this happens all the time. It would seem like common sense that a defense attorney would be able to bring in the fact that she had a boyfriend, it was a sexual relationship, and that's motive for her to fabricate the allegation. But before we can even do that, the law requires us to file a motion before the court to have the victim's preferences be heard, for her to testify, and this is where the SVC comes in, and then a court makes a determination under a couple different factors under MRE 412 if it should be admitted or not. Now the problem we're having with this type of evidence, and then there's a whole host of things that could be MRE 412, and there's just a whole gamut of things that it could be. I'm just using a simple example. What happens now is that a prosecutor, let's say a prosecutor even agrees that this is relevant and is constitutionally required. A victim's lawyer will now come in and she says, nope, I don't want my past being put out there. I don't want them to know that I had a boyfriend that I was cheating on them on. And then the Special Victim Counsel files motions and comes before the court, and they are trying to stop us from being able to use any of this evidence. So it's one more way where the defense doesn't get a fair shake at the trial, where all of the evidence doesn't come before a jury, and where juries can make decisions without knowing all of the facts. And so that's where we're really seeing, and there's also something called MRE 513. We'll talk about that in a second. But we're seeing this interjection by another level of attorneys, basically, well, those who represent the alleged victim, trying to keep out, frankly, relevant evidence and sometimes exculpatory evidence.
And Tim, I'll give you another real quick example, and then I'm going to get to the case that's going on right now, or actually the case that was just decided. Another type of evidence that would fall in under this category is, let's say that someone claims that they were sexually assaulted and they go to a rape examination. A rape test kit is done, and there's cuts abrasions, redness in the female's vagina. Well, the investigators will write that down as evidence that the girl was forcibly raped. Hey, she has cuts, there's abrasions, it's red. That means that she was forcibly raped, which really doesn't necessarily mean that, but that's what they would want it to show. And then the defense finds out, wait a minute, she had sex that same day, or like 10 hours before, with 3 different guys. The injuries could have obviously come from the 3 other guys. We then would have to present that evidence, file a motion with the court, and then the SVC would then come in and argue why the fact that she had sex with 3 people is so embarrassing for her. While don't forget, your client's life is on the line, but it's too embarrassing for her. So it's therefore should not be admitted because it's going to be too embarrassing and gonna make her feel really bad, and it's gonna. But what's really happening is these SVCs, in my experience, are putting pressure on judges and trying to basically come in and kind of intimidate the judges into keeping this evidence out. Well, what happened in a recent case in the Air Force was the judge said, listen, we will consider what you have to say, but you're not a party to this court-martial. You're not the prosecutor. You're not the defense. So, we will consider what the victim wants or doesn't want, and I will consider that in my decision. But you're not a lawyer that's a party to this case and come in and file motions, make arguments, and things like that. Well, the appellate court disagreed. The Air Force Court of Criminal Appeals and said, you know what, they are. This person now has standing, this special victim counsel, to interject themselves into the court-martial, really throughout the case if they want, if it's necessary for them to try to defend their clients, the alleged victim's rights, protect her rights, and things like that. So they basically opened the door to these special victim counsels being now a third party fighting against the accused in a court-martial and trying to limit his ability to get a fair trial.
Yeah,
that's kind of the gist of what's going on right now.
Yeah, it's real interesting. We couldn't even imagine this in state court. I mean, imagine seeing a trial where it's almost, do we set up a third table in the room to have her rights protected? And the big question that I'm asking myself is, what does this ruling mean? Does that mean if if defense is doing a blistering cross-examination of the alleged victim, exposing her for being a liar or exposing the fact that she has serious credibility issues, does that special victim counsel have a right to then object? Do they have a right to try to interject at that point in time and try to stop the trial or oppose objections?
They can jump up to him and yell, objection, badgering. And under this ruling, although that's a TV objection, that's not a real objection. I could see something like that happening, and then the judge is being told, hey, listen, this guy has the right to interject himself into this court-martial. We might as well just have the special victim counsel sitting up there in the judge's chair.
And what's the jury? And my question is, what's the jury think? We did a previous episode on how important it is to have an unbiased jury. If they think that this individual, this alleged victim, truly is a victim, that she's been so victimized that the Air Force gave her own lawyer, what's the perception of that? I mean, you have to look at it that way too. Are we going to set up a third table? And that
Tim, let me tell you.
They gave her own lawyer.
One thing people need to watch out for is these special victim advocates or special victim counsels have been also trying to keep out victims' psychological records, which can be hurtful to the defense, because let's say someone is a pathological liar or somebody has a lot of psychological baggage. For example, this happened in a recent case of mine where the girl allegedly was abused by multiple men growing up. And she then took the stand, was crying, all emotional, talking about how my client, who touched her leg, ruined her life and destroyed her and gave her post-traumatic stress disorder. And we were not allowed at that point in time to bring up the fact that she was all emotionally fragile before she even met our client. And then what ended up happening is they opened the door, so we were allowed to bring all this evidence in that she did bring in some evidence, not all of it, that she did allegedly have a history of being abused, and it wasn't our client that made her so fragile and destroyed her by touching her leg. So lawyers and clients need to watch out, and defendants need to watch out for the prosecutors trying to stop the past sexual behavior from coming in, and also the psychological history of the alleged victim from coming in, because that could make a difference one way or another whether or not your client goes to jail.
Absolutely, because at the end of the day, you want to make sure that the jury gets all of the facts and that they make the correct decision. And what I'm seeing more and more and more in this war on sexual assault that all of the military is waging, they want to cherry pick certain facts. And you used your great example of the girl who's had her leg touched, says that she was so traumatized by it. They want a jury to believe that your client is the one who traumatized her, and your client did A, B, C, and D to this girl, but they want to make sure that they keep away from the jury the fact that she had all these other pre-existing issues. And then they want to blame all of these things that they know darn well the prosecutor knows that cannot be attributed to the accused. They want to keep all of that away from the jury, which is cherry picking. I think is fundamentally misleading to the trier of fact, all under the auspices of, well, it's too embarrassing to the alleged victim. It's too, her rights aren't being protected. Well, at the end of the day, I'm not saying that that they don't have certain rights that need to be protected, but when you weigh her rights to being embarrassed by the fact that she had a gangbang a couple hours before, or the fact that maybe something a little less, that she was sexually assaulted as a minor, whatever it happens to be, when you weigh that against the fact that you have a service member who could be incarcerated and made a felony a convicted sex offender, you need to make sure that all of that evidence can become before a jury properly, so at the end of the day they get a fair shake. Because this is how we have wrongful convictions, Mike. This is how innocent people get convicted, is when prosecutors cherry pick evidence, only certain parts of it come before a jury and come before the trial. And my concern is that this SVP element is just going to have more and more of that.
Hey Tim, I couldn't agree more. And what we've been seeing in these cases, I have not. This issue was just decided, so I have not seen an SVC be able to interject him or herself into a case, which now they're allowed to do. So I'm interested in watching how that comes forward. And you know what? I think that the lawyer, that if you're defending someone accused of sexual assault, the lawyer for the accused has to aggressively try to go after the rights of the impact and really the rights of this special victim counsel. If they're going to come in there and start showboating and trying to help put your client in jail, then there's a few things you can do aside from standing up to them and trying to limit their ability to speak and try to hurt your client. And one of the things is when you're cross-examining the victim, and in your opening statement and in your closing argument, it's now fair game to go over all the fact that the victim has her own attorney, that the victim refused to speak to the defense, or her story only changed after her own lawyer, not the prosecutor, sat down with her and coached her on what a testimony should or should not be. And so I think what you could do is expose and even point out, without even saying it, but when you're talking about the SVC and how they're coaching victims and telling them what to say and what not to say, and reminding them that if a victim says, I don't remember, I have no recollection, then she kind of shuts down the defense's ability to cross-examine on that and expose what's going on to the panel to the best of your ability. Push the limits and let them know that this alleged victim isn't, at the previous hearing she was very aggressive. She wasn't crying. She was up in your face. Now all of a sudden her lawyer's in the room. Her lawyer prepared her, almost like an acting coach, and prepared her what she should and shouldn't say. Expose that to the panel, and that'll inflict some credibility damage on a bogus victim for sure.
I couldn't agree with you more, Mike. With SVPs, the special victim prosecutors, the SVCs, the onus really becomes on the defense attorney to expose all of this. Because if you are a novice defense attorney, you don't have the mental fortitude and the intestinal fortitude to take these people head on and expose them for what they really are. The odds of an accused going to prison go up tremendously. So it puts the burden more and more on guys like you and I and the defense bar in general to make sure that they are not timid, that they don't back down. If they're a captain and the SVC is a major or a lieutenant colonel, that they go take this head on and expose it for what it really is. And I always say this, but I think juries see this. And I think military juries do get it. As long as you do well in voir dire, they get it. And this coaching, it just doesn't work. You just have to expose it. So it puts more burden on the defense, which I gladly take on.
I completely agree with you. And here's an interesting something interesting that happened in a case I did about a month ago. We chose to not interview the alleged victim before the trial. We had her testimony at the Article 32. She didn't have an SVC at the Article 32. At the trial, she now had an attorney. He sends out an email, a real aggressive email, like, if you want to speak to my client, you got to go through me, trying to bolster and puff his chest. And so we're like, fine, we don't plan on talking to her anyway. And what happened was he started getting freaked out. We started getting all these emails. When are you going to talk to her? Why don't you want to talk to her? Am I missing something? And the thing is, he wanted us, and she wanted us to sit down with her, and basically the two of them, with the alleged victim and her lawyer sitting there, and ask her all the questions we were going to ask her on the stand, and we refused to do it. So what happened when we got into court, I mean, this is before the SVCs had any real standing, so he's pretty much stuck. But the alleged victim didn't know, because we had completely changed our game up from the Article 32. She didn't know where we were going. She got stumped on a lot of the lies she was telling. She looked terrible, and she didn't have a trial run. So lawyers should be very careful. Defense lawyers should be very careful between talking too much to these SVCs, if at all, and also revealing their strategies to these SVCs. Because don't forget, the SVC is not even a prosecutor. The SVC works directly for the victim, and if the victim wants your client in jail, that SVC will do whatever they can to ensure that your client goes to jail.
Yeah, Mike, you touched on a great controversial topic, and it's maybe outside the scope of this particular broadcast, but it's, do we interview the victim, the alleged victim in the case? What a great topic. But my take on this is, if they have an SVC or an SVP, everything I say to the alleged victim is going to go right back to the SVP or the SVC, and my entire strategy is going to be used. So if I'm going to do something foolish like that, I might as well write down my entire trial strategy, put it in a nice binder, and hand it to the prosecution. Because what happens is they spend the next week, month, prepping for everything that you've talked about. Now, the interesting thing we've done before, which always makes it good at trial, I'll interview a victim and talk to her about things I have no intent whatsoever of doing at trial. I'll lead them on path A, knowing I'm going to go down path B. And the interesting thing about it is I can tell that they're coached, because when they do their direct testimony, all their direct testimony is about trying to deal with everything that I've told them on my bogus plan A. Then we hit them with plan B at trial, and they don't see it coming. They're looking right, and the bus is coming left. They get run over. Yeah. And so that's a strategy that we employ quite often. But I see lawyer after lawyer after lawyer sit down with the special victim prosecutor, the alleged victim's paparazzi or her handlers, and talk about everything that's going on with the case. And after they do that, they meet with their handlers, meet with the paparazzi, meet with the prosecutor, and now their story's all changed. And if you don't expose that at trial, your client's going to go to jail, and you had a hand in doing it. So
yeah, Tim, what do you mean by the paparazzi? I heard you mention that. I know what you're talking about, but please explain to the viewers, when you say the victim's paparazzi, what are you talking about? Okay, the
alleged victims' handlers and their paparazzi. I see this at trial after trial after trial. If you claim to be an alleged victim, no matter how bogus the claim, you are immediately coddled, given a group of followers, told, hey, I've got a shoulder to cry on. You have 2 or 3 people that follow you everywhere you go, hold your hand, tell you everything's going to be okay. And that's fine, I guess, in theory. But the problem is they will tell you how to testify, tell you how to answer the defense attorney's questions, coach you in lying, coach you in deceiving, and then tell you everything's going to be okay and that they're doing it for justice. Every time I go into one of these court-martials, Mike, 2, 3, 4 people, all holding hands, singing basically Kumbaya. They're all GS-13 employees making $80,000, $90,000 a year, ginning up victims, okay? Because we've talked about this before. If there are no alleged victims, they're out of a job, and they follow them around and say everything's going to be okay. What they also do, Mike, is they sit in the court-martial, watch all of the testimony, and I've seen them go back to the alleged victim and tell her everything we're doing, and they change their testimony mid-trial. I see it all the time. They frustrate the hell out of me, but that's what it is. If you want an instant paparazzi, you want your instant 20 minutes of fame and your handlers, alleged sexual assault in the military, and you'll have them in 20 minutes.
All right, Tim, that's some interesting insight, and I completely agree with you on that. That wraps up this episode. Until next time,